Finally, we're going to look at remedies under the Uniform Commercial Code. It's not that different from remedies in contract generally. We looked at the fact that the preferred type of remedy is expectation damages. So the idea is that the party should be put in the position she would have been in had the contract actually been performed. So in the context of sale of goods, if the seller sells something and the goods either don't arrive or are in some way non-conforming, then we would look at how much it would cost the buyer to go somewhere else to get the benefit of whatever those goods might be. So we would either look at the difference between the contract price and the market price at the time of breach, and the seller would be on the hook for that difference. Or we can allow the buyer, if the buyer chooses, to cover by going to some actual seller, alternative seller, and then we would do whatever the difference is between what the contract price was and what the buyer ends up buying it for, as long as the seller that the buyer goes to cover isn't some completely outrageous seller who's way, way out of the market price range for that particular item. Now, sometimes the buyer could accept goods that are non-conforming, as we discussed earlier, as long as she notifies the seller of the nonconformity within a reasonable time period. Then the damages will be the difference between the value of the goods delivered and their value if they had actually conformed to the contract. So presumably there will be some sort of a price reduction given that there was nonconformity, depending on how big the nonconformity was. Damages for breach of warranty are the difference between the value of the goods accepted at the time and place of acceptance and the value they would have been if they had conformed to the warranty at the time. Now, when the buyer fails to make payment, the seller can, not surprisingly, withhold the delivery of goods. And when the buyer wrongfully rejects the goods for whatever reason, maybe the buyer says they don't conform, but they actually do conform, then the seller can potentially recover damages. And in that case, the idea is the seller can resell the goods and then recover the difference between the contract price and the resale price. That's really just the flip side of the idea of covering. It just allows the seller to resell and get whatever difference in price there might have been. Specific performance at common law is only under very limited circumstances. And so in the case of goods, you'll rarely get specific performance unless the goods are unique for some reason. So I gave the example in the previous module about the sale of an artwork by a particular artist. Then there's really no ability to cover by going to someone else and getting an equivalent artwork because there's no such thing. And so sometimes in those kinds of circumstances, the court might award specific performance and require the creation of the good. But more often, they will try to come up with some way of measuring the monetary damages of not getting the benefit of that contract because specific performance is generally frowned upon. We don't want to force people to do things. It's deemed an infringement on their liberty interest.